of themes today, and each panelist will have the opportunity to share their knowledge on the questions that I ask today. Additionally, we hope that this session will be interactive. So we will have a Q&A in the last 10 minutes of the webinar. So please feel free to put your questions in the question and answer box as they come to mind. Then we'll answer the questions towards the end. So moving on to the next slide. For those who are not familiar with me, let me provide a brief introduction of myself. So I've been working in the data privacy space for a number of years, and I have had the privilege of helping big organizations, public entities, private entities, multinationals, as well as SMEs with their POPIA compliance. And over the years, I've developed a love for data privacy, and I'm very excited to talk about it today with the two experts who brings so much extensive experience and knowledge to this topic. So Professor Snail and Lucien, thank you for joining us. And although Professor Snail needs no introduction, I'm sure everyone is well acquainted with him, especially in this space. Can you introduce yourself?
I'm Sizwe Snail, practicing attorney, specializing in cyber law. And yes, I have had a specific interest in data protection and still currently have.
Thank you. And I'm also joined by Lucien Pierce, my director. Lucien, would you mind introducing yourself?
Thanks, Lucinda. It's great to be here with you and my old friend, Professor Sizwe Snail. We go back a long way. I've been involved in the privacy space also for quite a while, as far back as when the POPIA was still thought of or was contemplated in a white paper back in 2003. And ever since, in fact, some of our submissions have been incorporated in various versions and various drafts. But since 2003, we've watched, we've advised, and eventually welcomed POPIA into law. And that's my background. Of course, like Professor Snail, cybersecurity is one of my interests. Privacy, I've worked on quite a bit with Lucinda, and it's something that we absolutely and thoroughly enjoy. So if you ever look out there or Google us, you're going to see a heck of a lot about privacy online associated with the three of us. Thanks, Lucinda.
Thanks, Lucien. So moving on to the next slide, these are our themes for discussion. So the first theme is understanding the data breach, a case study on that. What went wrong? Why did the DOJ receive a fine? The second theme is securing or safeguarding information. So what does POPIA require in terms of making sure that your organization's information is safe, as well as how do you put in place measures to mitigate your risk so that you don't end up in the same place as the DOJ? The next theme is enforcement, fight or flight. So how do organizations receive a fine? What's the enforcement process? And what do you do in the event that you get a fine? Do you just roll over or can you challenge it? And then our last theme is what next? What can we anticipate from the Information Regulator in the future? And how can your organization prepare for what's coming next? So moving on to the next slide, I have this picture, and this is some food for thought. So IBM, in IBM's stats, it's reported that the average cost of a data breach is 2.79 million. That roughly translates into over 49 million rand. That's a large amount of money. And this amount not only includes a fine that one can receive from a regulator, but it also includes the cost of remedying that breach, getting lawyers involved, getting professionals involved, like your PR people, to manage reputational damage. And because the Department of Justice is a public entity, this money is going to come from taxpayers. So, Lucien, my first question to you is, can you explain how the data breach happened? How did it unfold?
Okay, so for us lawyers, it was a particularly serious issue because it affected many of us who practice in particular areas, particularly those who practice in family law and estates. But what happened was that in 2021, the Department of Justice suddenly found that many of its systems were offline. Computers couldn't work, files and databases couldn't be accessed. The courts themselves couldn't record proceedings, and a really important part of the administration of justice was down. Maintenance payments that the Department of Justice facilitates could not be made. And even more serious, I suppose, because of the really sad circumstances that people found themselves in, is where people had recently passed away. Families were not able to access funds in the deceased's account to at least bury them because there were processes in place that could occur through the Department of Justice, and those processes were completely came to a standstill. So it really affected many people in those circumstances, exacerbating the situation where they were attempting to lay someone to rest. So that's essentially what happened. The Department of Justice just couldn't operate.
Okay, and so maybe you can go a bit more into the systems. Why were these systems online? What were, what was the cause of these systems going down?
Yeah. So essentially what happened was, because much of the Department of Justice's operations happen online and on computer systems, they found themselves subjected to there was some debate as to what it was. The official or the public version was that they had a ransomware attack. So I'm not particularly or exactly sure what it was, because they say it wasn't a ransomware attack. But what transpired was that because the systems hadn't been properly protected, their antivirus software wasn't operational. They had a special system called an intrusion detection software that wasn't in place, so they couldn't monitor and couldn't get warnings about whether they were under attack. And a third software called SIEM, which essentially monitored any events that were occurring on their system. That license hadn't been renewed either. And in fact, the license was due to have been renewed in 2020. So it was almost a year that the systems weren't in place. So it was because of the failure to renew those licenses and therefore have all these protections in place that the, let's just call them hackers, to use a colloquial term, were able to come in and disable the department's systems. So that is what actually happened and what they were faced with at the time.
Thanks for that, Lucien. So since the Act has been in place, there are many organizations that have experienced data breaches. The Information Regulator reported that it has received over 500 reports. But what makes the DOJ so special? Why were they? Why did they receive a fine as opposed to other organizations? Why did the regulator decide to show its teeth in this case?
So what happened after the breach occurred was that the Information Regulator and various other bodies received reports from the Department of Justice about this incident. The Department of Justice, of course, in terms of POPIA, was obliged to report this compromise to the Information Regulator. The Information Regulator then undertook an investigation to determine exactly what had happened, how it had happened, and what was required to remedy this. They then issued early in May of this year what is called an enforcement notice. Now, an enforcement notice is a an instruction, if we can call it that, that is issued in terms of POPIA. And that enforcement notice essentially identified what the issues were, or what the causes were. And in making its recommendations or its findings, the Information Regulator essentially said that there were three things that the Department of Justice needed to remedy. It needed to implement the 3 licenses that had not been put in place. They needed to renew them. And I suppose we could say 2 issues. Secondly, they needed to take action against the employees who were responsible, or the persons who were responsible for not renewing the licenses. Those were the 2 main findings and instructions. And what the Information Regulator did was afforded the Department of Justice 31 days to do that. Fair amount of time. Those 31 days elapsed and there was nothing. No report back, no confirmation that this had been implemented. They were given a couple of days grace. And after that, the Information Regulator decided that because they were not being taken seriously, I assume that's why they did it, they issued a notice that required or an administrative fine against the Department of Justice, which essentially was 5 million rand, fine for not complying with that enforcement notice.
Thanks, Lucien. Thanks for that. And that brings us to our second theme that we're going to discuss, safeguarding information. So what it seems like is that the DOJ received a fine from the Information Regulator, partly because its response was bad, but also because it did not have adequate security safeguards to protect its information. So, Sizwe, a question for you. What security safeguards does the Act require organizations to put into place?
Thank you for that question. So one of the conditions for lawful processing of data is indeed the fact that you must have proper security safeguards in place. You will find that just about Section 19 right across to Section 22, dealing also with data breaches. But in essence, to the layperson, what exactly is this positive duty? It's a positive duty to have technical and organizational measures in place. So you must have technical as well as organizational measures in place to ensure that the data that you are keeping has been, kept confidential. So what are technical measures? So technical measures are software, like you heard, the softwares that were not put in place. Organizational measures is the you and I factor, the human factor. How do we as humans at an organizational level treat data? Do we have policies in place? Do we have systems in place to protect the data of our clients or the data subjects put in data protection language? And in doing so, you must have internal as well as external, assessments, self-assessments to see whether, your software is still up to date. Does it still, do the purpose that it's supposed to? If you got an antivirus 6 years ago, surely you must have updated that, and so forth.
Thank you, Prof. And I think you touch on a very important aspect, because in as much as the Act requires you to put these security measures in place, it also says that you must monitor and verify these security measures. And if we take the DOJ case as an example, they had antivirus. They initially started, they put antivirus in place. They put this software that can monitor and detect intrusions. But what they did not do is ensure that those things remain up to date, ensure that they are working and that they are still protecting the organization. So just in terms of a practical level, Professor, what are the key things that organizations can do to ensure that they have sufficient data protection measures in place and prevent similar incidents.
Okay, so to be able to determine whether you have adequate safety measures in place or whether you need to improve them, I think the first inquiry should be what type of data do we process as an organization?
Yeah.
If you are a farmer in the outskirts of South Africa, most probably a laptop will do the trick. You will most probably have your Excel spreadsheets there, the people that you're supplying, maybe your employees. You don't need much security in place there. But if you are a bank and you have millions of customers and you have hackers out there from all over the world who want your client's data, then obviously the self-assessment process is a completely different inquiry. You know, then we go strictly now into the technical measures, right? And I don't profess to be a specialist on technical measures, but you should have certain hardware and software in place that is adequate, that is up to date in terms of, you know, the state of the art to ensure, well, and you can't exactly ensure, right? You can't never ensure that you're not going to get hacked, but you can try to reduce the possibility, let's answer it like that, of being hacked, right? So, like I said, it starts with the self-assessment. And then once you've done the self-assessment, you then put these technical and organizational measures in place. And then, like I said, you know, you move further, then you assess the internal risks, the external risks, and ensure that everything is up to date.
Perhaps if I could sum in, Prof, and you know, that point you made about state of the art, I think it stood out for me. Would I be correct to say that what is expected is that you would implement what is best practice in your sector? You would look at what your peers are doing, and you would apply that standard to yourself as well.
Right.
You know, if you're below the standard, and if something does go wrong and it ends up in court, a judge is simply going to say, well, what was expected of you in this particular sector that you were working in? So I would suggest, you know, doing that exercise as well, looking in, but also looking at what best practice is being implemented in the sector.
Great, thanks for that, Lucien. So what we've seen in the past is that the regulator is ramping up its enforcement activities. Yesterday, the regulator announced that it is doing an assessment on Nedbank to determine its POPIA compliance. And this assessment, as I understand it, was out of the regulator's own initiative. And this, you know, this sort of brings to mind something, you know, where, or what I would imagine, where your stepmother, your mother-in-law, not your stepmother, your mother-in-law ends up on your stoop and then comes in with a white glove and then, tests to see if there's any dust on the shelf. So, Lucien, can you explain to us a bit of that process? You know, why can the regulator do this assessment? Why can they come into your house and see whether, you know, you are being tidy, whether you are being compliant?
Oh, my mother-in-law did that in the first few years of my marriage. Yeah, she loves me to leave it. So I think perhaps for me, what's important to emphasize is this assessment term. It sounds pretty benign, but if you go and read the provisions, all the provisions that touch on this concept of assessment, it is actually almost similar to an investigation. So it has very serious connotations, because an assessment can quite easily translate very quickly into an enforcement notice. If you go and look at the Act, you look at the Section 89, which deals with the assessment provisions, and you look a little further on, and you find out that it actually can turn straight into an enforcement notice without having to go the route of an investigation. But the idea behind the assessment is to come in, whether it's by way of a complaint or a report by a third party, or, as you mentioned, Lucinda, as a result of the Information Regulator's own initiative. And we're likely to see quite a few more of these assessments happening. If you look at the report that the Information Regulator put out earlier this year, if I'm not mistaken, out of all the activities and reports that happened, there were quite a few hundred. Of that, about 97 were assessments that it conducted both for the private sector and the public sector. Interestingly, the Information Regulator's view was that there was quite a lot of non-compliance in the municipal space. They didn't exclude the private sector because there was non-compliance there, but many of the assessments also found that there was almost no compliance as far as POPIA is concerned. So that assessment, should not be treated lightly. As I said, it can translate directly into an enforcement notice for anyone who has an adverse finding as a result of that assessment.
Thanks for that, Lucien. So maybe moving a step further, in terms of the fines process. So we know that the Information Regulator can conduct this assessment, but I'm interested to know in terms of how does an organization receive a fine from the Information Regulator, and how does that process work? How does the investigation work, and so on?
Okay. So I mentioned the assessment, perhaps, seeing that we were dealing with that. Let's say that, and I'm not saying Nedbank's systems are not compliant with POPIA, but let's use them as an example. So the Information Regulator, assuming that it was of its own volition, essentially would have given Nedbank 7 days notice to say, hey, we're coming in. It can be done on much shorter notice, but in this instance, they would likely have said, in 7 days' time, we're coming in and we're coming to do an assessment. They do the assessment, and let's say they find that Nedbank is non-compliant in many respects. What they would then do is they would issue an enforcement notice, an order that Nedbank is obliged to remedy whatever is at fault within the organization. And that's why I mentioned from an assessment, you can actually go directly to an enforcement notice. That enforcement notice would then outline what the issues are that the Information Regulator has found and direct that they be remedied. And in this case, it's typically within 31 days that this is required to be done. Of course, if this isn't done, then the Information Regulator then, of course, takes the next step, and it essentially issues a sanction. As was the case in the Department of Justice, this is an administrative fine. There's also, of course, the potential for imprisonment, because those are some of the sanctions that can be applied depending on what aspect or what section of the Act has been contravened. So that is the one route to getting to an enforcement notice and ultimately some sort of sanction. The other route, of course, is by way of an investigation, where somebody complains and the Information Regulator then proceeds to investigate the matter, and it follows a similar route where ultimately, if there isn't compliance, then an administrative fine is potentially the outcome of this. And of course, there are further steps that can go from there, but we can deal with that in due course.
Thanks for that, Lucien. So just going on the further steps, and maybe Professor, you can come in here. An administrative fine is not where it ends. There is scope for civil action. Professor, can you describe how that process works?
So previously, we would have to rely on the common law to sue for your personality interests, for your personality rights. So we have the old case of Ifi and the lady whose picture was taken on the billboard without her consent. And that is the common law position, to say that you can sue for that type of a breach where there was no consent concerning the use of your personal information. Our legislature has now said, look, we are now going to codify this common law right that you have, they have now codified this, and you can now approach a court of law on the basis of statute to say that there was a breach of my data, this was the extent of the breach, and as a result of the breach, I have suffered damages. So you don't have to prove your damages in terms of the common law, but in terms of Section 99. But I think in essence, you are still basically having to prove your claim and the extent of the breach before the court can make any finding as to the quantum of what you are deserving in terms of that action.
Yeah, and I think what makes it even, I don't know if exciting is the correct word, but what I really find good about the provisions regarding civil damages against a responsible party, somebody who has breached the act, is that the information regulator can actually step in and act on that individual's behalf, that responsible party's behalf. Because we all know that if you're up against a corporate as an individual, and corporates typically have these huge litigation budgets and can stretch matters out for years if they feel like it. In this instance, you've got the information regulator, which essentially carries that flag for you, incurs all the costs on your behalf, and pursues the responsible party, the person who is responsible for the compromise, on your behalf. And ultimately, if there is an award, there's an apportionment of sorts where the information regulator gets certain costs, and then the balance is paid out to whoever the claimants are. So the great thing about that is that there's a great public interest element, because you, as the individual who has suffered some sort of harm, doesn't have to incur that cost of load shedding, that cost of the litigation. And that's what I find really exciting about it. You have a flag bearer who will incur the costs on your behalf.
Okay, thanks, Lucien. And also just to discuss in terms of maybe looking overseas, what are the damages? What kind of damages can one receive? What are the amounts? Are people receiving millions of rands when they are suing responsible parties, or will they receive something that's quite conservative?
Yeah, so from what I've seen, you're not going to get rich as a result of litigation against a responsible party, somebody who has compromised your personal information. The likelihood is that you are probably going to get cover for credit checks, if you want to call it that, where the responsible party, the person who caused you harm, would typically pay for some sort of insurance as well, over a period of a year or two. So it's not likely that you're going to come up with a huge amount of money. If I had to quantify it, and of course, unless there has been major harm, because what the Act does talk about is how much your privacy has been infringed, the sensitivity of the information. That is a factor. But from what we've seen thus far, typically with breaches, if you look at Experian, if you look at Liberty just before the Act came in, TransUnion, that is typically information that relates to credit records, ID numbers, etc. That information will typically be used for purposes of fraud, or some other type of something related to that. So in that instance, the likelihood is that there will be some sort of award which will cover you for insurance and for credit checking during the course of a year or two. You're not going to get rich on a claim here.
Okay. But I think it's still quite damaging to organizations, because let's say there's a data breach that affected, 10,000 data subjects. I mean, that's a major breach. But even if you give them each 100 rand, if you multiply those costs, it's still, I'm not very good at math, but it's a lot of money, depending on how many data subjects were affected.
Yeah, I think, if we take the Experian breach, that involved, if I remember correctly, about 27 million data subjects. And in that case, if you think about an award of, say, 100 Rand for each person, which would cover insurance and also credit checking during the course of a year or two. 100 times 27 million data subjects is a lot of people. It's at 270 million or more. My maths might be bad. Please don't laugh at us, actuaries and accountants out there, but it's a very big number. So yeah, you know, for the individual, it might not be a huge award, but for the responsible party who's paying up, it could be really damaging.
So just moving back to the Information Regulator, and Professor, we know that you've worked for the Information Regulator's office. So I want to discuss what are the powers of the Information Regulator when investigating non-compliance, specifically search and seizure, the dawn raids that we speak about. I think many organizations are quite concerned about that aspect of the Act.
I don't want to speak jargon, but I would say the regulator has rather a wide, should I say, wide powers to request information. And the regulator doesn't just request, in fact, it can demand information. And if you don't give the information, you could fall foul of such a demand of information. Yes, in addition, it also has powers, as we know, to do assessments, which may mean physically going to the office of the responsible party and doing those things. So I think the regulator does have teeth, as they would put it, but a wide powers to handle complaints. For instance, if the regulator asks you to come to its offices to come and report about the state of affairs of your compliance, and you don't pitch, as we know, as our former state president, you could be guilty of contempt of the regulator. And as jurisprudence has now shown us, you could even go to jail for that.
Yes.
So, you know, the office of the regulator, I'm quite happy now that it is operational. For the greatest of time, I think a lot of people were saying, look, here's another white elephant. They're never going to get their powers. Nothing's ever going to happen. And, you know, it's quite clear that the regulator is working now, and that steps are being taken against non-compliant parties. And I think as the body of data protection law, you know, through enforcement notices, through the actions of the regulator, and hopefully also reviews of the regulator, we will start seeing the extent of, you know, the powers of the regulator, what can be done and what cannot be done.
What I find interesting, just adding to what you said, Prof, is, you know, if you look at the provisions related to search and seizure, to how warrants are issued, it's not an unreasonable process. In fact, it gives the responsible party, the person from whom the information is being requested, a certain amount of time to comply and to even challenge the warrant if necessary. So there are lots of protections in place as well. You know, if a step is missed, you could quite possibly be able to challenge that warrant. But what's important also are the provisions regarding a warrant being issued and executed without prior notice, the so-called dawn raids that you've mentioned. And even in those instances, there are protections built in, you know, whether it's the right to have an attorney come or a legal representative come in at the time that this is happening, to protecting all the privileged information and legal advice that would have been provided relating to this particular matter. So yes, there are serious implications for the responsible party, but there are also protections in that entire process.
Okay, thank you very much for that, Lucien. So let's say an organization, your organization, receives an enforcement notice. What steps can organizations take? So what we've seen from the DOJ's response is don't do that. Respond. Make sure that you are, you respond to an enforcement notice. You take the corrective steps. But what happens if you don't agree with the regulator's assessment? Do you just have to then pay up the fine? Is there a right of appeal? Can you do something about it?
So as I mentioned earlier on, there is a right of review. So the regulator exercises what we call quasi-judicial powers. Okay, it does have certain powers that must be respected and that are enforceable. However, should you not be happy with the actions of the regulator, even in terms of administrative action law, you would be able to take the regulator on review to a court of law. And this is quite common. I mean, if you look at the cases in Ireland, in the UK, all over Europe, right, where regulators have given hefty fines, some of the companies have actually turned to the courts of law to have those fines reviewed, to have them set aside. So definitely the buck does not stop with the regulator. You still have your right to access to the courts. And should you feel that whatever decision the regulator has made is unfair or has gone ultra vires beyond the powers of the regulator, you surely do have the right to approach a court of law for further redress.
Yeah. Yes. And perhaps for the attendees, please, if you have any questions, don't forget to put them in the Q&A. Also, if you've come in late and we're looking a little squashed, there is a functionality. If you click on the image that you're looking at, the feed, you'll see 3 little dots next to our production manager's name. Click on that and select full frame, and that will make us look a lot better. But to add to that, there are also the options, so the enforcement notice is delivered as it was to the Department of Justice. In that instance, you've probably got three options as well. Before you do anything further, it's pay the fine. Let's come to some sort of arrangement, of course, to pay it off if it's going to make a serious dent in your pocket. And of course, the third is simply to say, no, I disagree with this. And you go and lay charges, which is what the Information Regulator can do under the Act, basically to refer it to the courts. They report it to the SAPS. And if I'm correct, Prof, they then prosecute it through that mechanism. And you have an opportunity to challenge the enforcement notice if you are aggrieved at what those findings are.
Okay, I think that's good to know that, especially for organizations who are certainly worried if they receive a fine, can they do anything about it? But as Lucien and Professor mentioned, there is a lot that you can do, and there's a right of recourse. So moving on to our next theme and our last theme is what can we expect from the Information Regulator going forward? Earlier on, I did mention the Nedbank case, or not the Nedbank case, the Nedbank assessment. Can we expect more from the Information Regulator doing these kinds of assessments? I'd like to get both your views on this. So we'll start with Professor Snail.
I think there's a very big expectation out there from the public, from the parliamentarians who created this piece of law, who also are the oversight body of the Information Regulator, that the Information Regulator get on with its work. So I think the Information Regulator in the next couple of months will really be busy, trying to really do its work and to show the public, and like I said, and to show the parliamentarians who are doing the oversight that they are doing the work. I think, a limitation that maybe the regulator may have is the amount of money that has been allocated to the regulator. And I think if the regulator really pushes hard and does its work and exhausts its current budget, there would be grounds to, get an increase on the allocation that the regulator is getting from government. And maybe also, one should consider incentivizing the regulator to say that, instead of taking all these fines and throwing them into the fiscus, that maybe we look at an 80-20 rule where the regulator takes a part of the fine, which will assist it to do more and more work with the resources and the additional resources that it will be making through fines. So I'm speaking to Parliament. The parliamentarians are out there. Let us consider not only throwing the fines into the fiscus, let us allow the regulator to benefit some of these fines so that they can get on with it. They can get on with the work. I'm on this side now, so I can talk.
Yeah, I think that's a very good point, because in the past I've received quite a number of questions in terms of what does the regulator do with the money they're going to receive from the fines, and certainly investing that money back into the regulator to make the regulator stronger is definitely a good idea. Lucien, your thoughts on this?
Yeah, I think, Prof. Snail made a very important point that a strong regulator is important. And you might ask, well, we're just dealing with data. What does it matter? Well, I think an important point was made this morning. I was driving to work, and on the radio, the presenter was interviewing Gauteng Premier Panyaza Lesufi. And he made the point, a very important point, that we're talking about jobs in Gauteng, in the economy. And he said to the presenter, I'm going to say the presenter's name so you know which radio station I was listening to. My other radio clients, please don't get upset. He said, Clement, our economy for a long time has been dependent on mining. It's been the major source of our revenue. But we are seeing a decline in mining, and we have to make the move to an information economy. And the information economy relies on data. Now, if we're going to become an information economy, we need to make sure that we have a sufficiently strong regulator to protect that data, particularly the personal information that is going to form part of operating that information economy. In a recent article I mentioned, we want data centers to be built here. We want business process outsourcing to be brought from Europe to be set up here. We want call centers to be set up here. All of those industries are going to involve personal information that needs protection, real protection from a strong regulator. So to Professor Snail's point, the regulator is going to need to be empowered more in terms of its budget. If you think about it, to take on a big corporate, whether it be a bank or an administrator, a medical administrator, or a telecommunications company that has had a major breach, for them to spend 50 or 75 million rand on a top-notch legal team is a drop in the bucket. For the information regulator, that is probably its entire budget for the year. I'm not sure what it is, but I remember it was a pittance a few years ago. So we definitely are going to need to see a strong information regulator. And I think we are certainly going to see a lot more enforcement notices and a lot more fines. The one that I'm keeping an eye on, and I think is about to explode very soon, I'm not sure if you would agree, Prof, is the Department of Health, which to this day, as far as I'm aware, hasn't ensured that all the COVID-related information that it collected during COVID, that it was tracking, has either been deleted or anonymized. And the information regulator, I think, I have no inside knowledge, but I suspect there's going to be a big fine, far more than what the Department of Justice received, because of the sensitivity of the information involved.
Maybe just to add on to what Lucien is saying, for those of us who go to the courts, to the magistrates' courts, to the CCMAs and the high courts, there's all this data that is being taken by all sorts of security companies when you access the courts. And as a legal practitioner, I'm quite curious to find out what is happening with that data. I think it is a powder keg waiting to happen. And I think one must seriously consider, from the judiciary's perspective, to find ways of not taking this data in that manner. maybe getting legal practitioners to have ID cards, to reduce the manner in which our data is being collected at some of these courts, and to ensure that our courts do not become places of data abuse.
Absolutely. Yeah.
Thanks for that, Professor. I just want to take a question that we have from the Q&A. So the question is, what would trigger an assessment by the regulator? Can it be conducted without a complaint having been received or a data breach? And this is from Tlanganan. So, Lucien, would you like to answer this?
Thank you, Hlanganani, for that question. So if you look at the Act, which basically deals with assessments at Section 89, it says that the assessment can be conducted in response to a request or a complaint, or the information regulator can undertake an assessment on its own initiative. So it's quite possible that without a complaint ever having been filed by anyone, that the information regulator decides that it's going to focus on a particular sector or a particular industry or a particular entity in the public or private sector, and go and determine whether it is complying with the POPIA requirements or not. It might have been triggered by persistent breaches that are occurring. So let's say perhaps that you have on 2, 3, or 4 occasions reported as an entity that you've had some sort of compromise. The regulator might think to itself, hang on, this is happening too often. We better go and see what's happening in this organization. It might well be that as a result of reports in the public, the information regulator has observed certain behavior that it merits investigation or assessing as well. So, Hlanganani, the reality is that the information regulator doesn't need to be prompted by a third party to come and do that assessment.
Thanks, Lucien. Another thing that you've mentioned that I just want to discuss a bit more is the fact that the information regulator may see that there are some complaints coming from specific companies or organizations, or a specific organization has reported a lot of data breaches and they want to go in and see and investigate this. What do you think are going to come out of these assessments at the moment? Do you think the regulator is still, are they there to help the organization, or do you think they are doing this in order to eventually give more fines?
I think I don't think the regulator is out there to make some money. I think there is a very genuine desire, and if you look at its powers, it talks about educating, it talks about assisting in terms of compliance. So its role is not just as this big bulldog with sharp teeth. It's there to also assist and prod you in the right direction. So it's not just to go out there, do the assessment and issue fines. If you think about it, if you look at the South African Police Service compromise in that very tragic incident where the personal information of those assault victims were publicized on a WhatsApp group, in that instance, the information regulator investigated. It issued an enforcement notice, and the South African Police Service complied and remedied what was required, and that is the end of the matter. So there has been a positive outcome as a result of that. Something else that just popped into my mind is that, and it goes back to helping the economy. If the information regulator is seen to be improving compliance within our economy, we are more likely to obtain what is called an adequacy rating, if I could call it that, adequacy decision. And you might ask, what is that? Now, one of our biggest trading partners, the European Union, has a law called the General Data Protection Regulation, GDPR. And GDPR says that in terms of the exchange of information between the EU and different jurisdictions or other countries, if a jurisdiction or a country like Argentina or Uruguay, believe it or not, a small country like that, as adequacy compared to other countries like Australia, which still don't. If we are able to get adequacy, all of those sectors that I spoke about, outsourcing, data centers, business process outsourcing, call centers, will be able to happen smoothly without the need to have a more robust regulatory process and agreement process between the parties transferring. The information can just freely flow into South Africa and back to the European Union. So seeing a stronger regulator that both enforces strongly and strictly, but at the same time promotes compliance and helps people to comply, brings real benefits to the South African economy.
Thanks, Lucien. That's a very good point. We have another question from Letta, and this question I'll direct to Professor Snail. How would we ensure that this proactive assessment is not abused? Is it even included in the legislation? So I think, as we mentioned, it's included in Section 89 of POPIA. But Professor Snail, how will the regulator ensure that that they're not abusing this process?
I think the regulator will not go and target organizations willy-nilly. As we've already said, they have limited resources. Mm. And I think when they do these assessments, they're going to be more on an industry level, like recently, they were also checking political parties and PIA compliance. Now, as you've heard, they're busy with the bank. They may be busy with the banking sector. You never know these things. So I don't think the assessment procedure will be abused, because that in itself opens the regulator to, being challenged legally, as Lucien put it out there. Some of these organizations are not just going to allow the regulator to waltz in. They will go and suit up and armor up. So I think the assessment powers will be used sparingly by the regulator and on a needs basis. And when it's on the own initiative, I think it will be, if there's a widespread data breach that has not been attended to, or if there's certain reports about a certain industry, I think that is where the regulator will then use these powers. Save for that, I think the complaints procedure will still be the primary entry point of complaints to the regulator.
Thanks, Professor. So we have 2 minutes left, and in this 2 minutes, I'd like to just get your last closing thoughts on what organizations can do in terms of POPIA compliance, and just ensuring if the regulator does pitch up, what should they have in place? How do they ensure compliance in terms of the Act? What's the most important and critical points?
Start with me. Yes. So I'm not a fan of checklists, because checklists do not make you legally compliant. I think that's one big fallacy that's out there, that, if I go and I get a certain checklist or toolkit and I check all the boxes, then I'm POPIA compliant. No, that doesn't work like that. You need to do that introspection as an organization. Yeah, you need to say, what data do I as an organization process? And then based on, and I know it sounds like I'm repeating what I said earlier on about the farmer and the bank, but that is in essence what you need to do. Yes. You need to establish what type of data you're processing, and based on that, you then need to decide what are the steps that you have to take to safeguard data. How do you, within the organization, remember we said technical and organizational measures, how do we within the organization put policies in place? How do we ensure that everyone in the organization complies? I always used to say, when I was still doing some roadshows with the regulator, I would say it's not just the guys at the top, the senior managers, and it's not just the guys in the middle, all right? Also, the cleaning staff need to be educated about POPIA. You're going to say, the cleaning staff? Most definitely, yeah. Okay? imagine a situation where the cleaning staff is throwing away papers that have not been shredded. Okay, imagine this in a doctor's practice. All right, it's even worse in a doctor's practice. Now you've got all this information that the cleaning staff could possibly be harvesting for third parties, or God knows, you know, there may be someone who may be stealing that data. So POPIA compliance is all around. You need to do that assessment yourself, and then based on that assessment, have in the right people to assist you in making sure that you're complying with POPIA based on your needs of the POPIA. I hope that gives you an answer and hasn't complicated it even worse.
Thank you. Lucien, your thoughts?
Yes, Prof. Snail makes a very good point. The practice of tick boxing is not going to help your organization. You know, we've seen over the time that POPIA has become fully in force, all kinds of offers out there. POPIA in a box, you pay X amount of money and we'll send you a ready-to-use toolkit that will get your organization sorted. But the reality is that, in my view, amounts to window dressing. Having something, just some sort of facade of compliance, is really going to get you into some trouble if ever the Information Regulator does an assessment, or if ever you have a compromise that becomes public and the Information Regulator comes in, whether it's on immediately or on some sort of notice. You will not, if you're a large organization, get your house in order and have proper organization-wide compliance, right down to the cleaners, as Prof. Snail has said, in 7 days. So our approach is to say, do this properly, do it thoroughly. If you haven't started, start. We know it's not a quick process, but if you at least get started and something does go wrong, then you'll be able to say to the Information Regulator, yes, we are at fault, but look, we're 30% through the way, through the process of getting compliant. Please just give us a warning. And that's where you will benefit from doing it properly. Because if you just take a window dressing approach, when things go wrong, that's when you're going to be caught out, and it may be far worse for you. And then the last point, of course, is if you are properly compliant, you will then reduce. Prof. Snail said earlier, you know, it's not, I suppose I should use a different way of saying it, but it's going to happen to all of us at some point in time. But when it does happen, at least you will be able to demonstrate that you did your best, firstly. And secondly, if you've got some proper systems in place, there's a stronger likelihood that your competitor is going to be the target as opposed to you. And who do you want to be? The one who is breached and compromised and has reputational harm, or the one that is shown to be compliant and respects privacy and data?
Thanks, Lucien. We've actually gone over time. So to our viewers who have joined our webinar, thank you for joining. Thank you to Professor Snail, and thank you, Lucien. If our viewers want to get in touch with you, Professor Snail, how can they reach you?
It's actually quite simple. There's only one Sizwe Snail in the entire planet. So it's as easy as Googling me.
Okay.
You can either find my details regarding where I work as an attorney, or if it's an academic thing, you can always send an email to Nelson Mandela University as well.
Thank you, Lucien.
Likewise, we're out there. All you have to do is look for PPM attorneys, whether it be on Twitter, whether it be on LinkedIn, and who knows, very soon we might be on what is it called? The new Threads. We might be on Threads too. But if you Google us, you will find us. And if you want to remain up to date, at least twice a week, there are new developments in the law. Check us out and follow us on LinkedIn or Twitter. Thank you.
Great. Thank you, and have a good day.